I'd like to welcome everyone to the Nashville Bar Association Town Hall meeting with our 20th Judicial District Attorney General Glenn Funk, who has been kind enough to join us today to talk about issues in his office and in the criminal justice system here in Nashville that arise out of the COVID-19 pandemic. General Funk, thank you for being with us today.
Glad to be with you.
I'd like to start with just a general question. The landscape in our courts has changed pretty dramatically over the last couple of months. Can you give us just a broad perspective on how that has affected things in your office?
Well, with the criminal justice system, it is unique in the state. As we work to try to open up restaurants, concerts, sporting events, barbershops, any of those institutions, people who come and enter those are doing so because they want to get a haircut or they want to get a meal or they're going to the grocery store because they need to get some food. But in the criminal justice system, it's the only place where the government is compelling someone to come into a building or to handle a case or to do some business. And so we've got to be really careful about what we're doing as we work to try to make sure that victims are supported, that defendants are held accountable, that the constitutional rights of both victims and defendants are respected and make sure that those are enforced. But it's tough because, we tell defendants you have to show up for court or else your bond's going to be revoked and you're going to be thrown in jail. Victims and witnesses get a court order, a subpoena to show up for court. Jurors receive a court summons to show up and sit as a jury. And so if we're going to compel attendance, we've got to make sure that we do so in a safe way and we do so in a way that actually makes sure we're paying attention to community safety and make sure that we're taking into account the constitutional rights of all the people that are going to come in contact with the criminal justice system. So it's been a real challenge. What we have been doing for the last 2 months is handling pretty much only the jail cases. If a defendant is in jail, either unable to make bond or has had their bond revoked or a probation violation be lodged against them, and they are in jail, then we have been running courts for those individuals every day and trying to see if we could go ahead and either resolve those cases, have hearings in some cases, see if some folks that are not a threat to community safety can either have their bond released, bond reduced, or even just have them released on their own recognizance. Some probation violations, if it's for a technical violation, maybe reinstate the probation. And we've been working to try to make sure that if you are in jail, your case is going to proceed as scheduled and without any undue delays. Folks who are on bond, who have either posted a bond with a bonding company or people who have been released on pretrial release through the Sheriff's Department or on their own recognizance, those individuals, we have continued the case, continue those cases, and we're working to make sure that those cases are heard as promptly as possible as soon as we can have a plan in place that's approved by the Supreme Court and can go forward in a safe manner.
For the persons who are in jail, you said those cases are proceeding. Have they been proceeding in person or have you been relying on technology?
When we can rely on technology without violating the constitutional right to confrontation, then we do so. If it's an arraignment and the person is just going to be entering a plea of not guilty. If it is a plea to a misdemeanor, we can do that remotely where they're not have to be brought in from the jail and into the courtroom. If it is a bond motion where we've got an agreement between the state and the defense attorney, we can do that remotely. But anytime someone is charged with a crime and there's going to be a preliminary hearing where the witnesses testify against them and the case is bound over to the grand jury, or if there's a probation violation where they are subject to continued incarceration because their probation has been revoked. In those cases, the people are actually brought in from the jail, brought into the courtroom, and then we actually have witnesses who take the witness stand and testify as to what the basis is for the charge.
And for those proceedings that are occurring in court, what social distancing and other safety measures have the courts been taking, and has your office been taking?
Well, the courts have been limiting the people in the courtroom to 10 per courtroom. The current order that's just been approved by the Supreme Court indicates that it can be limited to 10, excluding court personnel. So there will be a handful more people in the courtroom now than there have been over the last couple months, but not a significant number. People in the courtroom are required to be social distance. They're going to be required to wear a mask. We've got hand sanitizer being placed throughout the building, in the Birch building. And as we open up courts in the future, we will be making sure that there's someone who can take the temperature of everybody that comes in the courtroom to make sure that no one who has symptoms of COVID is even going to be inside the building of where everybody else is going to be for the court proceedings. Constitutionally, a victim has a constitutional right to be present in the courtroom when they're having their case heard, and so the victims are always in the courtroom. But generally, support people, whether it's family and friends of the defendant or family and friends of the victim, those support folks are not in the courtroom at this point. There will be oftentimes a victim witness coordinator, someone from our office in there, as well as the lawyers for both sides and the court personnel.
You mentioned the 20th Judicial District plan for reopening that, as I understand, was just approved by the Tennessee Supreme Court yesterday. And it specifically addresses support persons and says that that's going to be a court-by-court decision. What is your feeling about that provision, and how do you intend to address that with cases going forward?
Well, obviously a judge decides which of his or her court staff is present in the courtroom. The criminal court clerk always has a representative in the courtroom. We are going to be working on how many of our lawyers need to be in a courtroom at a given time. Obviously, the lawyer that's actually handling that case, but do we have a second person actually in the courtroom? We're going to be still limiting the numbers of our lawyers that are going to court to make sure that we have as little exposure to our office or that could possibly carry it throughout the courthouse as possible. But first and foremost, we want to make sure that victims have their day in court and can be present for that. And then many times whenever there's a hearing, the witnesses are excluded and through the rule of sequestration have to be out in the hallway anyway. But at the conclusion of their testimony, they will be excused from the courtroom instead of, as normal, invited to stick around until the end of the hearing.
You discussed over the past few months that most of the proceedings have been limited just to your jail dockets. Under the new reopening plan, do you anticipate that a broader number of cases are going to start to have in-person court hearings?
Yes. In the 6 criminal court level divisions, which are primarily all felonies, those judges will start having a limited number of bond cases as we work toward trying to resolve some of these felonies. We also are working toward trying to have some jury trials in July, but that creates own problems. Our jury boxes are built to house 14 people, 12 jurors and 2 alternates in the jury box, and those are not folks that are 6 feet apart from each other. Though Dr. Hildreth met with our office, the public defender's office, and the criminal court judges and indicated that as long as people wore masks while they were sitting on a jury, that would be safe. I'm sure we would want to put in a few extra precautions in there to make sure that jurors felt safe while they were fulfilling that responsibility of citizenship. We also are going to have to make some changes to the way we select juries, because what we have done in the past is we would summon 180 people, and they would all meet in one room on a Monday morning. And then as the courts said that they had a jury trial ready to go, then groups of 30 to 40 people would be taken up to the individual courtrooms. And whether we had 6 trials going or 3 trials going, the courts would notify the jury assembly coordinator and then take those jurors up. Well, we have to make sure that anyone who is summoned can feel safe in the way that we're going to be handling not just the jury trials themselves, but the jury selection process. And having 180 people in the same jury assembly room at the same time is not a safe way to handle the jury selection process at this time. And so, talking with presiding Judge Binkley yesterday, he's talked about having some jurors show up in the historic courthouse and some show up in the Justice Birch building. We may have to limit the numbers of folks, and we may have to stagger some start dates and start times for jury trials in order to try to make sure that we can actually provide jury trials for those cases that we're not going to be able to resolve through any type of plea negotiation. So that's going to be a real challenge. With regards to the general sessions courts, I talked with both presiding Judge Linda Jones as well as Deputy Clerk Patty McNaney this morning. We're trying to reorganize some of those dockets to where we limit the number of cases for folks that are on bond to roughly, well, we'll have one set of folks for the domestic violence cases, but for all the other cases, try to limit those to around 50 a day in the morning, and then that will be set for preliminary hearings or resolution, with roughly 75 a day in the afternoon, which will just be kind of a settlement docket and not be for hearings, to where those folks won't be in the courthouse for as long. We can limit exposure that way by controlling those dockets, but still trying to make sure that we can cut back on any of the backlog that's been created over the last 3 months by us not being able to handle the bond cases.
I want to take a brief pause to let everyone who has joined this conference know that if you have a question for General Funk, if you'll use the chat function at the bottom of your screen and submit the question across either directly to me or to everyone on the group chat, then I will make sure that your question is asked. Going back for a moment to the 20th Judicial District Plan for reopening, one of the provisions that I found to be interesting, and I'm curious about how it affects the operations of your office, is that lawyers are going to be required when entering the AA Birch building and the historic courthouse to wear masks, and also to provide not only their clients with a mask, but also their witnesses. I anticipate that implicates lawyers in your office and victims and other witnesses. What's your plan for meeting that requirement?
Well, we have been able to procure masks for every person that works in our office: lawyers, victim witness coordinators, investigators, support staff. And it is already a rule in our office that if you are even walking the hallways, you have to have a mask on, even in our office. The only time you can not have your mask on is when you're actually in your own personal office. That's also our rule as soon as you walk into the courthouse. And so we've already been wearing a mask at all times in the Justice Birch building. We have a victim witness department in our office. We have 20 victim witness coordinators. And their job is to make sure that victims and witnesses know the court dates, know what's going on in court, are up to date, can answer questions, and can provide support in any number of ways. And part of their job will also be to make sure that we have masks available for every person who's going to show up to testify on behalf of the state, to where their entrance into the courthouse can be as seamless as possible.
You talked a little bit about the challenges with having jury trials and the hope that some trials are able to resume in July. I'm curious about what concerns, if any, you have about the ability of the court to get a jury that fairly represents the community when different demographics in our community may be more affected by the COVID-19 risk than others.
Well, I have seen that the COVID pandemic has had a disproportionate impact on African American and Latino communities. We need to be aware that it could impact the ability to make sure that we have juries that are a fair representation of the community. You know, I am concerned. It's traditionally been that we send out jury summonses to 200 to 250 people in order to get 180 people that can actually schedule the time to take off from work, get childcare, do whatever in order to be present to participate in juries and show up for their jury service. In a situation like this where people have very real concerns about their health and have concerns about whether or not we as a criminal justice system are going to make sure that this is a safe place for them to come and fulfill this obligation, this responsibility. I don't know how many people we will have to issue a summons to in order to get a proper number of folks for us to have a week's worth of jury trials. I also want to make sure that people know that it's safe, but you can't make sure people know it's safe until we make sure that it is safe. And so we've still got a lot of work to do over the next 6 weeks in order to make sure that we can guarantee people that this is as safe of a set of protocols as we can possibly establish to where people can feel comfortable coming into the courthouse.
During the time that we've been under these safer at home and stay at home orders, what concerns should we be aware of for vulnerable people, including domestic violence victims, children who aren't going to school, who may be victims of crime, and how has your office been keeping up with those issues and trying to mitigate them?
Well, as far as in the courthouse, when we met with Dr. Hildreth, he said that there were a number of things that we needed to do, and we included those things in the plan. We needed to make sure that before people even entered the building, we needed to make sure that they were symptom-free. And so we're going to make sure that temperatures are taken, and we make sure that they answer questions indicating that they're symptom-free before they come into the courthouse. Limit the number of people on an elevator. Try to minimize the number of people in the courthouse at any given time. Place the hand sanitizer out. Make sure that we have the masks. And the other thing is to do a frequent cleaning, meaning not just once a day, but several times during the day, a thorough cleaning of the areas that are the public areas in the courthouse, and make sure that not only and we clean those areas, but that we have proper social distancing in the hallways. The judges have already put some markings down as far as what 6 feet intervals would be. I've been up in the courthouse, and sometimes folks that are waiting for court, even with tape on the benches, end up with 5 or 6 people on a bench that really shouldn't have more than 2 people on, and so that can be difficult. We try to make sure that people are reminded if they're not properly socially distancing. But this is really important because all it takes is one person with COVID to come up and potentially leave infectious droplets all through a floor of a courthouse, and all of a sudden our courthouse becomes the epicenter of a new COVID outbreak for Davidson County. And so we're doing all we can to stop that. With regards to what we are doing with victims and witnesses is we are trying to make sure that we have communicated with them to the extreme to make sure that they know what's going to go on in court, perhaps have them on call to where they don't actually have to come into the courthouse unless their case is actually going to be heard. No sense in them coming up, waiting in the hallway for 2 hours only to find out that the case is going to be continued next week. We want to make sure that the only people that are coming into the courthouse are folks that we really have to have come into the courthouse, because the fewer people that come in there, then the fewer people can be exposed or could do some exposing to whatever they're carrying to the other people in the courthouse.
Can you speak a little about the communications between lawyers in the criminal justice arena in terms of settlement discussions about continuances and motions? I don't practice criminal law personally, but I actually interned in your office as a law student. So I know that most of those communications tend to occur in the courtroom and in the hallways. How are those being handled? Is it a DA by DA protocol?
Well, it has always been that most of the discussions on criminal cases all across the state have been primarily done on the court date and in person in the courtroom. However, we have always had a policy, a practice where if you know you've got a case coming up in a few days and you call the district attorney, the assistant district attorney will meet with you and spend some time trying to resolve the case even before you get to court. We're trying to make sure that both the defense bar and all the ADAs know that we really would like for no case to be on a docket where you haven't already talked to the defense attorney ahead of time. For that end, we are working on making sure that we can publish the direct line for every assistant DA in the office to every member of the defense bar, to where it's as convenient and as efficient as possible, to where you don't have to just call the general number and then wind through the prompts in order to get to the assistant district attorney that you're trying to reach. We want that to be as efficient as possible, to where we can make it so that the normal course of business is that you've already talked to the ADA about your case before you even have to go to court. And that way, a lot of the court appearances that are going to end up in continuances can go ahead and be continued, to where the defense attorney and the attorney's client don't have to come into the courthouse that day, and hopefully we can decrease some of the foot traffic in the courthouse. But we're trying to ramp that up to the best of our ability. And sometimes, as a person who was a defense attorney himself for 25 years, sometimes you don't know how you can resolve the case until you've had a chance to talk to your client at a time when you're also talking to the prosecutor. And sometimes you need to be able to talk to the police officer that's the witness on the case to find out some nuance that might clear up any potential misunderstanding between what the defendant has told you about what happened and what the officer wrote in the warrant. Sometimes that has to be done in court. So I don't think we can eliminate all in-court discussions, but I'm hopeful that we can cut through a lot of the superfluous court appearances for defendants and defense counsel.
A lot of work has been done between your office, the public defender's office, the defense bar, and the courts to adapt in this time. And I know that some of the measures that you're taking haven't even been tested yet. For example, the staggered docketing, figuring out how to get people in the courthouse. But if you could kind of look into your crystal ball for a minute and tell us what you think might remain even after this pandemic has hopefully subsided or we have a vaccine, some of the things that have been done, will some of those stick around after all this?
Well, I do think that, and I'm hopeful that on some of the non-adversarial proceedings for incarcerated defendants, that those can be used more frequently going forward, but with remote appearances. Anytime that we can cut down on sheriff's transport, then not only are we making sure that the transport officers are safer if they don't have to transport as many people, but we're also saving money for the county, because if we have fewer transports, then the sheriff can take those resources and apply them in other places that are needed in the sheriff's budget. And so I'm really hopeful that we can do some of that. I also think that if we can learn how to do that well, that it could end up saving court time and court resources as well. But I am still resolute in thinking that We never need to go to a situation where we have adversarial hearings on criminal cases where someone's liberty is at stake through any type of remote testimony, because I think the right of confrontation that's enshrined in the Constitution is something that is one of the most fundamental pieces of our criminal justice system.
Recently, the Davidson County Public Defender filed a petition for the early release of certain jail populations and inmates in the state, and your office opposed that petition. Can you talk with us a little bit about how your office is handling those requests?
Sure. If you go back 6 or 7 years ago, our typical jail population was somewhere around 2,000 or more individuals, plus another 1,000 at the CCA facility, which were people serving short felony sentences. Prior to COVID, by making sure that we did not use the severe sanction of incarceration other than on those for whom we needed that severe of a sanction for either incapacitation purposes or for the specific deterrence involved, we've been able to reduce that number from a total of roughly 3,100 every day down to 2,100. Through our efforts at trying to make sure that we could drive the numbers down as low as we could while still maintaining public safety, the number as of last night was just under 950 pretrial, combination of both pretrial folks and people serving a misdemeanor sentence. And then there's an additional roughly 700 to 800 people serving those low-level felony sentences, to where we've cut the numbers in half over the last 6 years, with probably maybe 20% of that coming through being very careful about how we work to reduce the jail population here during COVID. The sheriff had said that he wanted, for safety reasons, to try to get that number under 1,000. We were at that point roughly 1,050 to 1,100, and we're now down to 950, 945, right in there. So he's able to do the proper quarantining in his jail facilities in order to try to keep his jail from being someplace that COVID could rip through his population, and he can actually try to do as much as possible to make sure that those folks are safe. But the folks that are in there are folks that we have reviewed their cases individually, every single person, and there's a real good reason for public safety that we have felt like we needed to advocate for continued incarceration.
I imagine that your 25 years as a criminal defense attorney gives you a nuanced view on a lot of these issues. How do you think the COVID-19 pandemic has forced our country, our city, our state to rethink the criminal justice system?
Well, I know that in the 10th Judicial District in Cleveland, they have cut their jail population just through COVID by 30%. By actually being open to some of the reforms that we've already done. I think what's important, and what I think a lot of the members of the Tennessee legislature are reevaluating, is shouldn't we go back to kind of the fundamentals? And if there are people who we need to incapacitate, people who have committed murders, people who have committed a series of home burglaries and they're just not going to stop, people who are rapists, people who are abusing children. There are those individuals who are dangerous to us all. And those folks we need to incapacitate through lengthy sentences. There are other people for whom we need to make sure that the threat of incarceration is important, because we need deterrence both for the whole community to not do bad criminal acts and hurt people. And we also need the specific deterrence where this individual learns that they can't keep doing this crime. But the answer to every offense doesn't necessarily mean incarceration. And what we're trying to do is to make sure that we are safe and that we are healthy and that the system is fair. And sometimes you just kind of got to step back and look at what you've been doing, and is there a good reason for why you've been doing it this way? And let's try to see what we need to do to have a reset. And a fairly good amount of the state legislators have already been at least looking at criminal justice reform in ways that we have already been putting in practice. And I know that several of the state legislators who aren't even from Nashville have reached out, asked me what our numbers are, how we've achieved certain things, what we're doing, and we're really trying to focus on, let's make sure that the violent criminals are who we're spending most of our resources on. And that's been an attitude, right, a philosophy about prosecution that's actually well received across party lines, because what we're all trying to do is have a safe community, but we're not really being good stewards of our citizenry, and we're not being good stewards of our treasury if all we're doing is trying to set a record for how many people are incarcerated.
With the safer at home and stay at home orders, of course, the focus has been on the safety and with regard to people's health, but can you give us some insight into how crime has changed with everyone staying at home and being quarantined to their houses?
Now, we do not have exact statistics yet for the last 3 months. From looking at the dockets, we have seen fewer physical arrests, in part because the police department has been putting a push to, if it's not something that absolutely has to be an arrest, let's give a citation for that offense instead of let's make a full-scale arrest. But on the major cases, the shootings, the stabbings, the rapes, those seem to be having, unfortunately, about the same level that we had seen pre-COVID. And that is frustrating to me, because I was hoping that everybody would stay home and nobody would commit a crime during this period of time, but that's not been the case. But I don't know, it seems like it's been pretty consistent, and when we get all the stats in, we'll know. I have heard of other jurisdictions that have seen domestic violence, for instance, rise by 20 to 30%. We're going to very carefully look at those numbers, and we'll report back on whether or not Nashville has seen a spike in that. Between the Office of Family Safety and the good work that Diane Lance is doing in trying to support victims and making sure that they are connected to services, housing, counseling, whatever, and the efforts that we are still making by running 2 domestic violence dockets a day, we're trying to make sure that we stay on top of that, and at least making sure that victims get the support they need to hopefully stay safe. But with the stay-at-home orders, other jurisdictions have seen a sharp rise, and we're looking to see what's happening here in Nashville.
Is your office currently prosecuting, or do you anticipate that your office will prosecute violations of the safer at home orders?
Every case rises and falls on its own merits. Just the general stay-at-home order is one thing. It's another thing if you've been diagnosed with COVID-19 and you've been given an order by the health department and you violate that. And so we just got to look at every one of those, at every one of those cases, if and when they come through.
I want to remind everyone who has joined us on the video conference that if you have a question for General Funk, if you'll use the Zoom chat function to send your question across, and I'll ask it for him or ask it to him. General Funk, have you taken away from this situation any silver linings, or is there anything that you're particularly grateful for during this time?
Well, I'm really grateful that we have not had large violations of the stay-at-home orders, right? I'm grateful that Nashville businesses have done their best to work with Mayor Cooper and try to make sure that we don't have any type of situation where there's a confrontation between city leaders and our city's business leaders. I understand the frustrations. I think our courts have worked really hard, and I think our 17 circuit criminal, chancery, probate judges, as well as our general sessions judges, have done a wonderful job of making sure that they and their staffs come in and continue to provide the services that are required by our Constitution to make sure that victims' rights are protected and that citizens who are accused of crime, their rights are protected as well. Here in our office, I have to tell folks that we are trying to social distance and to do as much work from home. And yet when I walk through the hallways, I see a lot of folks that are here in the office, and I have to cross-examine them to some extent about, why are you in the office? Why are you not at home? Well, I had to come in because my files were here and I had to do this. And so I think that commitment to making sure that whenever we can open up on the bond cases, and that as we do these cases for the folks that are in jail, that commitment to making sure that these cases are still handled right. This is a situation where our office and the courts have really been working extra hard, I think, to make sure that even in this situation, this is not treated as a vacation. This is treated as, let's work extra hard to make sure that we do this case right. And I will give a lot of credit to the defense bar, and especially the Metro Public Defender's Office, because they are staying on top of who's in jail, why are they in jail. They're communicating with us. We're reviewing every case on the case-by-case basis, and we're trying to make sure that we can communicate with them. But they're staying on top of every one of their cases, and that's something that I think as a community we should all be proud that we've ended up with a bunch of institutions that are committed to working together to try to work our way through this. And in a case like Ms. Johnson's motion for essentially a mass release, we worked through a lot of cases, and we continued even after that motion to work through those cases on a case-by-case basis. And when we had a disagreement, that's what we have judges for. And so we had a hearing that was professional and appropriate, but we were able to do that in a way where the court system served its function in a way that I think was entirely appropriate and worked with the best interests of the community in mind.
We've talked a lot about how the pandemic and social distancing is affecting cases that where people have already been incarcerated or in jail awaiting prosecution. But for those new cases or cases that you're in settlement discussions, are concerns about the pandemic affecting what jail sentences you're offering in settlement negotiations, or even how you're dealing with court fines, given the financial difficulties that people have experienced because of this?
Right. The facts of the current situation in our community are yet another variable that we consider as we're trying to figure out what is the best resolution of a case. When the public defender and defense attorneys say, hey, you can't do social distancing in a jail situation, they're right. And we have to understand that. On the other hand, there are some people who you cannot just say, well, you know what, you're not going to be responsible for this crime that you just committed. You're not going to be held accountable. You're going to have to, at some point, be accountable, and that might require you to be incapacitated through jail. And so we have to balance that. It's kind of easy to be a defense attorney sometimes because you're just an advocate for the person that you're representing. Whereas a district attorney, judge, probation officer, what we're looking at is community safety, which requires a balancing between community safety and the rights of the citizen accused. So in some ways it requires us to be extra thoughtful, put in a little bit of extra work on these cases to factor in all these additional concerns. But at the same time, we cannot just agree with a defense attorney because we do have to think about community safety.
General Funk, thank you so much for being with us today. We really appreciate you taking the time to speak to NBA members about the issues facing your office and facing our courts.
Sure, I'm glad to do it. And if any other questions come up, Glenn Funk at jis.nashville.org, or if you would like to get back together for another one of these meetings, sometime toward the middle or end of July, after we've attempted to have some jury trials, I'll be glad to come back and give you an update and a report on how we're doing at that point.
We appreciate that so much. And thank you everyone for joining us today. This will bring our town hall with General Funk to a close. Thank you.